When talking to the media about their clients' cases, good attorneys make statements that help position the client to resolve the case favorably. But great attorneys go one step beyond. Hi everyone, my name is Wayne Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, one thing that separates good attorneys from great attorneys when talking to the media. It's not enough when addressing the media and the public regarding a client's case for an attorney to simply defend the client or to discuss the merits of the client's case. That attorney must communicate to the public in a way that gets the public to support the client and see the world from that client's perspective. In other words, attorneys should be giving public statements that draw empathy from the client's key audiences. That is, the audiences that the client relies on to prosper in whatever way the client defines prospering. I recently came across two examples in the media that I think display attorneys who didn't go this extra mile. So the first example is of an attorney who was vouching for his client, who is a well-known baseball writer. And I'll put a link to this example and the next example below the video. This baseball writer was accused of assault against his wife and making death threats against his wife. Apparently, his wife and him are going through a divorce. And the attorney talked publicly about the case, which I agree that he should have, but he made a statement that seemed almost flippant about death threats. And the statement attempted to explain why his client made the death threats, but it didn't really draw empathy. Had the attorney instead said something like, "My client said things he didn't mean in the course of a heated argument," as anyone who has gone through a divorce firsthand or who has seen a divorce up close knows, these kinds of conversations are heated and people often say things they don't mean. Instantly, that communicates to the public that the client's going through a difficult time, and it allows anyone who's been through a divorce or has known people who's gone through a divorce to nod their heads and understand exactly why the client may have done what he did. It's not saying he should have, but at least it gives an example and a reason that people can understand. Another example from northeastern Pennsylvania, a school district in that part of the state sent letters to about 1,000 families who have not paid their children's lunch bills. And the letter said that if the parents don't pay these bills, don't pay for their student lunches, that those students can be taken from them and placed in foster care. When the school district's attorney went on the local NBC TV station in a response to public outcry about these letters, he said something like, "Well, we wanted to get people's attention, and we did. That's why you're here, because people are complaining about getting in trouble for not paying their bills. How shameful." Again, we see an attorney trying to do the right thing. He's trying to enforce his client's rights. But it's not working because it's not drawing empathy from the public and the school district's key audiences, in this case, the taxpayers and the parents of the district's children. Had that lawyer instead said something like, "We understand that times are tough in the district, but when parents don't pay for their students' lunches, then the school is forced to pay for those by cutting other important programs. We ask parents pay their bills promptly so the school district does not have to make these cuts that could damage our kids' educations." Do you see the difference? We're drawing empathy from the public, and we are telling the parents, look, we understand times might be tough, but at the same time, we need your help in solving this problem. It empowers the parents to come to the rescue and do something for their kids by paying the bills on time. Here's what I want you to take away from this video. The next time you draft a public statement regarding one of your client's cases, I want you to do two things. First, I want you to draft the statement in a way that positions the client both to resolve his or her case favorably, but also positions them to maintain a good reputation and goodwill beyond the legal proceeding and amongst the client's key audiences. Then I want you to actually reread and reevaluate that statement and make sure that it couldn't be interpreted negatively by that client's key audiences. And to do that second thing, you should enlist a colleague, and you wouldn't tell them much about the case. Make sure they're not someone who's intimately familiar with the case, but tell them to step in the shoes of someone who does business with the client or someone who would be a key audience of that client, maybe a business partner, maybe a member of the general public, whomever, and then have them evaluate that statement and see, based on this assumed identity, if they think that this statement does more harm than good and does not help keep the client in a favorable light amongst its key audiences. I'll leave you with this parting thought. Former U.S. Supreme Court Justice Anthony Kennedy said in Gentile versus State Bar of Nevada in 1991 that an attorney's duties do not begin inside a courtroom door. An attorney cannot ignore the practical implications of a legal proceeding for that client. Great attorneys, media-savvy attorneys, follow this advice. They don't just give public statements that help a client resolve their legal dispute. Great attorneys, media-savvy attorneys, give public statements that help position those clients for after the legal proceeding ends. Those statements position the client to maintain a good reputation, maintain goodwill, and allow them to prosper well after the legal proceeding is behind them.